So this is, I think, part two of the sort of hot topics in asset recovery. So welcome, thank you very much for staying or for coming back from your coffee. I'll start with introductions. On my immediate left is Howard Sharp, QC of Ardent Chambers. He is a founder of Ardent Chambers in Jersey. He was for around 5 years Solicitor General for Jersey, acts for governments, financial services, businesses, and has extensive experience in sort of tracing and asset recovery, dealt with confiscation linked to proceeds of corruption regarding President Moi in Kenya, which he might want to talk about if we have a spare 5 minutes. On his left, Simon Thomas of Baker & Partners. Baker & Partners, very well known asset recovery firm in Jersey. He is an English barrister and Jersey advocate, so he can talk on both. And he's also specialises in asset tracing, international fraud, and is one of Jersey's preeminent practitioners. So you have two of Jersey's finest advocates at your disposal here, and you also have me. My name is Jonathan Tickner. I'm a partner at Peters & Peters in London, and we're a sort of specialist asset recovery practice, business crime, civil fraud, and so on. So that's introductions dealt with. In terms of what topics we've chosen, I think that we're going to try, if we can try and make this interactive. So it's sort of the last session of the day. If people have questions to make, observations on what we're talking about, then feel free, please, to raise your hand, introduce yourself, and certainly either make your point or ask a question. We obviously have a very nice selection here of investigators, insolvency practitioners, international lawyers. It's a good mix, and hopefully we can have some sort of engaging conversation. In terms of what we are talking about, we're going to cover dishonest assistance, particularly in relation to banks. That's on the back of Singularis Holdings, which is a Supreme Court judgment that was handed down around 11 days ago. We're going to also talk about privilege against self-incrimination, particularly in Jersey, and we'll try and cover that in the UK, asset freezing and civil forfeiture as well, and some other emerging developments. And we're going to finish off with sort of confidentiality clubs and how they're used in the context of fraud proceedings. And they can sort of be a barrier and an assist. So just starting with, I'm going to kick off with talking about dishonest assistance in relation to banks. And Singularis, which is a very short judgment that was handed down unanimously by the Supreme Court. As I say, Lady Hale, I think, is the sole judge who gave judgment on that. And it's a nice Christmas present for claimant fraud litigators. That case upheld the existence of a bank's duty, which is kind of called the Quince Care duty, after a case in 1992. Let's just quickly start with Quince Care. I'm going to give you a sort of rapid summary of that. Not of the case. The case is not that interesting, but where was the case? The case concerned Barclays Bank loaning £400,000 to a company, of which the company's chairman, this is in 1992, the company's chairman drew down and misappropriated $340,000. The bank sued the company for the funds. The company claimed that the bank had breached its duty in allowing the funds to be drawn down in the first place. And the judge there held that there was an implied term of the contract between the bank and the customer that the bank will observe reasonable skill and care in and about executing the customer's orders. So it's an implied term, a duty imposed on banks. The ratio of that case, just to expand on that, was that there would be liability if the company executes an order knowing it to be dishonestly given, or shuts its eyes to the obvious fact of the dishonesty, or acted recklessly in failing to make such inquiries, as an honest and reasonable man would make. And the bank should refrain from executing an order if and for so long as it was put on inquiry by having reasonable grounds for believing that the order was an attempt to misappropriate funds. So in that situation, a bank should sort of, if it gets a request to make a payment out, particularly if there aren't millions of payments going out of that account, there is a duty to potentially to pause and to think. Now, Singularis comes along. Now, that is a long-standing litigation. Some of you, I'm sure, will know about the case. It's a Cayman Island company and was set up to manage the personal assets of a Saudi businessman, Mr. Al-Sanea, who was the sole shareholder, director, and also the chairman, president, and treasurer, so effectively the controlling mind of the company. There were 6 other directors, all reputable, but none exercised any control over the management of the company. So Al-Sanea has very extensive powers. He can obviously take decisions for the company, has signing powers over bank accounts and so on. And it was a substantial business. It traded and it ran up debts. Now, the appellant in this case, so Singularis was bringing a claim. This is not Singularis, this was the liquidator of Singularis, because the company went into liquidation with very large creditors. It was bringing a claim against its investment bank. This is a London subsidiary of a Japanese investment bank. And in 2007, the company and the bank entered into a financing arrangement where the bank, Daiwa Capital Markets, provided loan financing to Singularis to enable it to purchase shares which were the security for the repayment. In 2009, the shares were sold, the debt was repaid, Daiwa was left with cash surplus of 240 million. It was also left with a lot of creditors. And when the company ran into difficulties, Al-Sanea, the controlling mind and sole shareholder, he basically directed that money should be paid out to third parties. And by doing that, he fraudulently deprived Singularis, the company, of that money by giving instructions to pay it away. So that's the sort of, that's the facts of the case. Now, Singularis brought a claim against the bank, and at first instance, Miss Justice Rose held that the bank should have realized that something suspicious was going on and suspended payment until it had made reasonable inquiries to satisfy itself that the payments were properly made. And it didn't. So the company, through its directors, its creditors, had been the victim of the bank's negligence. And the issue before the Supreme Court, because it went up to the Supreme Court, was whether such a claim for breach of a bank's quince care duty was defeated if the company's instructions were given by the company's chairman and sole shareholder, who was the dominant influence over the affairs of the company. So effectively, could the actions of the director and shareholder of Al-Sanea be attributed to the company? And the bank argued that if that was the case, if the fraud was attributed to the company, then Singularis' loss was caused by its own fault and not the fault of the banks. So you can see the argument. Having lost at first instance, it raised 3 defenses. That was illegality, causation, and equal and opposite claim against the company in deceit. Now, the Supreme Court unanimously held that for the purpose of quince care, the fraud of Mr. Al-Sanea was to be attributed to Singularis. And it said that effectively the bank was liable. Now, this is an interesting case because there is a 2009 case called Stone and Rolls, which was a House of Lords decision which revolved around, this is a Latin phrase, I never learnt Latin at school, so I'm going to pronounce this and I'm going to be corrected by one of my colleagues here, ex turpi causa non oritur actio, which effectively is a claimant will be unable to pursue a legal remedy if it arises in connection with its own illegal act. Is that fair? It's fair. I'm getting nods. So that case was roundly criticized by a lot of claimant lawyers, this House of Lords decision. And effectively, I think the House of Lords decision in 2009 has been put to bed by the Singularis decision. Effectively, in Singularis, and I'm going to read one paragraph from Lady Hale's judgment. She says that the judge at first instance was correct to say that there is no principle of law that in any proceedings where the company is suing a third party for breach of a duty owed to it by that third party, the fraudulent conduct of a director is to be attributed to the company if it is a one-man company. She effectively says that the guiding principle in Stone and Rolls can be finally laid to rest. And the context of this case is the breach by the company's investment bank and broker of its quince-care duty of care towards the company. The purpose of that duty is to protect the company against just the sort of misappropriation of its funds as took place here. By definition, this is done by a trusted agent of the company who is authorized to withdraw its money from the account. To attribute the fraud of that person to the company would be, as the judge put it, to denude the duty of any value in cases where it is most needed. Effectively, what's the point of having the duty if you're going to then sort of try and get out of it when a company goes into liquidation? And effectively, this was precisely the type of protection that is needed, and obligations on banks effectively to think more carefully. I think it's an important decision, and it's an important decision for claimant fraud lawyers, for liquidators, in thinking very carefully about what assets can be out there and what causes of action there are when a fraud is committed on a business, on anyone. So you can have a situation where, I know, lots of grannies are defrauded out of lots of money in some sort of scam. This is seen all the time. Money goes into a bank account. Lots of money. The bank account has only been set up 6 months before by one director, shareholder, never traded, and then £1 million is emptied out of that account in a period of weeks. This is not an uncommon fraud. I think now with Singularis there are real issues and questions about a bank's obligation there to effectively, if the company effectively has creditors, that company, even though it was just set up for the purpose of the fraud, could effectively turn around and sue the bank. So I mean, it's an interesting decision, and one that I think we should bear in mind.
I think, Jonathan, in the case, one of the issues would have been what do you need to show if you're suing a bank for dishonesty? Because inevitably the riposte will be, well, however bad the conduct that the employees of the bank and the bank has carried out, it might be serious negligence, but is it dishonest? And in Jersey, we've got some indication, I think some helpful indication that's come from our Royal Court in a recent dishonest assistance case. When faced with that question, it was a trust company to whom the fraudster had paid money, and the trust company had paid it out and was then sued by the loser, the people who'd been defrauded, for dishonest assistance. And it was the usual riposte, we weren't dishonest. And the court had to grapple with that issue. What does it take to decide that someone is dishonest? And the approach, or one of the approaches that the Jersey court took, because it's an objective standard, you can't set your own standard of what's honest and what isn't. The law says it depends on all the circumstances of the case. Well, that's not terribly helpful. How do we decide what circumstances are relevant and what aren't? And what the Jersey court did was to look at the trust company itself and say, what are the regulatory obligations that trust company is subject to? The Jersey Financial Services Commission has set out a code of practice for trust company business. Requires, for instance, there to be proper protection of funds, adequate records showing and explaining each transaction. And on the facts of the case, the Jersey court decided that there had been breaches of the regulatory and statutory regime, and that enabled the court to go not entirely all the way down the road towards dishonesty, but it helped it. It helped it with a structure for deciding what was dishonest and what wasn't. And certainly being able to show that someone was in breach of their regulatory obligations got the claimant a significant way down that road towards a finding of dishonesty. But I just want to go on and think about some of the more practical issues when suing a bank for dishonest assistance in the offshore context. Because, of course, as we know, it can be a very useful and powerful tool for asset tracing in offshore jurisdictions, allowing someone who's dealt with a fraudster to claim against banks, trust companies, and other institutions where they have assisted a fraudster in dealing with the proceeds of the fraud. And one of the big advantages is obviously that the trust companies, the banks, the institutions are likely to be deep-pocketed defendants when the fraudster, in all likelihood, is not worth suing or might have disappeared. So the focus in these cases is often what is dishonesty, as I've outlined. But before you get to asking what is dishonesty, of course, you've got to prove that there was a breach of trust or a breach of duty that the bank assisted in. And I want to look at some of the practical issues that have arisen in a case that's ongoing in the Jersey court at the moment, a case in which we act for the claimants, acting for a Kenyan car company against a major international bank. And the car company would import vehicles into Kenya, and the suppliers were very well-known brands. And for many years, at least from the early 1980s, some of the directors of the company entered into secret arrangements with the suppliers of the cars. The suppliers would over-invoice the Kenyan car company for the vehicles. The company would pay the inflated invoice, and then the suppliers would pay the inflated amount into a trust administered by a trust company in Jersey. Every 6 months, the agent of the directors would get in touch with the trust company and give instructions of how to pay that money away to other offshore accounts held by the directors who had entered into the fraud. And this scheme was kept secret, and this is the point of the claim. It was kept secret from the company. It came to light when a new CEO took over, and during the handover, his predecessor showed him a safe in his office and said, "In here you will find documents that show what's been going on, and you mustn't tell anyone, but you yourself will be entitled to have a share of this money." Well, the new CEO blew the whistle, and that led to the proceedings against the Jersey Trust Company, which went back for many years, because that's the first time, arguably, the company had knowledge of it. Now, in a dishonest assistance claim, you want to be focusing on the state of mind of the bank, the trust company in Jersey. But of course, you've got to prove that what went on in Kenya was a breach of the director's duty. And how do you prove that? Well, the obvious, because you're trying to prove that the company didn't know about it. This is a scheme that the directors had hatched, and the company had no idea. So you're trying to prove a negative. And in terms of proving that, the starting point, you may think, is pretty obvious. Look at the company records. Look at the board minutes. Look at the management committee minutes. No sign of it being discussed there. Look at the employment files of the directors. Is there anything in their contracts of employment that suggests they're entitled to some sort of offshore bung? No, there isn't. Look at the invoices from the car companies. Is there anything on there that shows a markup was there that is discoverable by the company? No, there's no sign of the markup. So it all looks pretty promising for a dishonest assistance claim against the bank, because undoubtedly the money had been transferred, and there were some pretty damning documents in the bank's files. But once you've started up the proceedings, you've then hit your obligation of discovery. And from our client's perspective, we're in Nairobi. They, as it happened, have a vast amount of documentation that they keep. There's ostensibly no discernible retention policy. We've got warehouse upon warehouse of old files and dusty material. I mean, some of this is really old. Some of it we discovered only partway through looking at the files, had been treated periodically with rat poison. So we had a couple of our associates hospitalized once we found out. But the practical question is, what do you do about that? What's your reasonable search? Because we talk in these conferences at a very high level for, I'd say, isn't dishonest assistance a great thing? We can all go and sue banks, and of course we can. But when you're down to the nitty-gritty of discovery, and you're proving a negative, how do you treat warehouses, warehouse upon warehouse of documentation? Well, there are new discovery guidelines in Jersey, with the emphasis, as there has been in the UK for some time, on proportionality and the overriding objective. And we got leave from the master. We said, we've looked at all the corporate documentation. What do you want us to do about these warehouses? Are we really going to find anything there? What we suggest is we'll look for anything that's on its face looks like it might contain something about this scheme, but the rest we'll do a dip sample, and we'll do a dip sample of 10%, an intelligent limitation of discovery, we said. And the master said, yes, that's justifiable, and he ordered discovery on that basis. And this is hard-fought stuff, as you might imagine. Appeal, the Royal Court overturned that. No, back to full discovery. So what we've got to go down to Kenya and look through all of these warehouses, look through all of the files. So we got some witnesses who came forward, said, you won't find anything about that scheme there because nothing was ever written down. There's no point in looking at the warehouses. So we go back to the master and say, look, here's a witness now, or a couple of witnesses. They say you're not going to find anything there. So can we please have another dip sampling order, 10%? He said, absolutely. That's why should you go back and look for documents? You say that there was no record of the scheme. You're not going to find anything there. And that was successful, the renewed exact application for dip sampling. Another appeal, again overturned, so we're back to going down to the warehouses and going through every piece of paper. Now, this isn't terribly sexy stuff. It's not, this is about dirty documents in Kenya, but it is an important point when thinking about the practicalities of bringing this sort of claim, because often in an offshore jurisdiction, your clients and your claim will be coming from elsewhere, other jurisdictions. You wouldn't have expected in a Jersey company or a UK company to have a level of obsessive document retention and no real way of organizing it. But that can make that cultural attitude in the company can make a real difference to the costs of bringing the claim and the practicalities of the claim. And I think the point I want to make about it is that, yes, you can find the basis for a claim in your local court, but it's really important to understand what your client's culture is, what does it do with its documents, how organized are they, and what's the extent of documents you may have to search. And it's the procedural aspects of bringing this sort of claim, which this case shows, are often the most significant impediments to bringing a claim. And I think the practical advice is if you're going to start up a claim, make sure you know what you've got, what you're dealing with, what documents your client's got from the start. Otherwise, you could be in for a very unpleasant surprise when undertaking discovery, and which could add very considerably to the costs of bringing the proceedings.
Does anyone have any observations or points to make generally about sort of disclosure in their jurisdiction or issues regarding document-heavy disclosure exercises? I just came out of court today where we were talking about water damage documents, but that wasn't particularly interesting. If not, should we move on to privilege against self-incrimination? Howard.
Thank you. Article 6 of human rights law is applicable both in the United Kingdom and Jersey, and it provides a fundamental right that preserves a person's right to a fair trial. And the European Court have confirmed that that right extends to what's called the privilege against self-incrimination and also the presumption of innocence. And the European Court, for understandable reasons, has sought to give these rights to people and give effect to them in a very broad and wide way to ensure that people's rights across Europe are being protected and that high standards are being applied. However, that's caused some significant problems because there's not always been a consistent application of the European Court's principles, and in some cases where the European Court has taken a decision, it's not obvious what the underlying logic is to the extent that the European Court has given full reasons, and indeed there are often conflicting decisions that one can't really reconcile on their face. And the problem, of course, with all of that is that ultimately what that produces is a need for the Supreme Court of the United Kingdom, whether sitting as the Supreme Court or sitting as the Privy Council hearing an appeal from Jersey, to try and wrestle with these conflicting decisions and determine whether and to what extent English and Jersey law should follow European case law, there being a starting position that where there is a clear and consistent line of European cases, they should be followed in accordance with human rights legislation. So I'm now going to speak for a couple of moments about the case of Volaw versus the Attorney General. I appeared on behalf of the Attorney General, where the Supreme Court sat as a judicial committee late last year. There was an enlarged panel of 7 judges over 2 days, and they handed down judgment this June. And they were considering the privilege against self-incrimination. And the issue or legal point had arisen because Volaw, which is a Jersey trust company, had a client who is a Norwegian resident, and he was the subject of criminal allegations in Norway, and in fact was convicted of those matters in 2013. And he was convicted of aggravated tax fraud, and the fraud related to a number of trust and companies structured that were administered from Jersey by Volaw. So Mr. Larsen was convicted, and he then appealed. In Norway, an appeal is effectively a second trial, and everybody starts again. And during the course of the appeal process, the Attorney General of Jersey, who provides mutual legal assistance, amongst other things, was asked to produce some further evidence to the prosecutor for use in that appeal. And so he served a compulsory notice on Volaw, requiring the trust company to produce various documents to be transmitted to Norway and used in what was effectively a retrial. Volaw refused to comply with the notice. They said in so doing would breach their Article 6 rights. And what they meant by that was that they were claiming the privilege against self-incrimination. They were in turn saying that to hand over the documents would have a tendency to incriminate them, thus raising a real prospect or appreciable risk of prosecution in the future. And so there was litigation all the way up to the Judicial Committee on this one point. Could, in the context of being served with a compulsory notice, could any person at all refuse to do so on the grounds of privilege? One might have thought, because compulsory notices are not new, what the Attorney General had served in Jersey happens through the Serious Fraud Office all the time, using their analogous Section 2 powers. But in fact, the law was all over the place. Although the European Court had, in 1997, in Saunders, of Guinness fame, although it had appeared in that case that the European Court had made a very clear distinction between answering questions in interview, to which privilege plainly applied, and providing real evidence, including pre-existing documents, to which privilege did not apply. Although that clear distinction had been made in the 1990s, the European Court had, since the Saunders decision, started to move all over the place, and in some cases appeared to remove the distinction altogether. And in fact, in 1 or 2 cases which were not brilliant in terms of the underlying reasons, had found a breach of Article 6 where the only thing the person hadn't done was hand over a pre-existing document. So Volaw, relying on some of these decisions, said that Saunders was no longer good law, and in fact, Article 6 not only applied to pre-existing documents, but it would be a breach of their human rights to now require those documents to be handed over. Ultimately, where the Privy Council, the Supreme Court, ended up was that they decided to take a very nuanced and flexible approach to the law. They got rid of the distinction in Saunders, which had been adopted by a number of English Court of Appeal decisions between 2000 and 2015. They said that Article 6 did apply and does apply to the obtaining of all real evidence, including pre-existing documents, but it was going to be a question of the particular facts as to whether or not there was a breach. And to date, the only cases that had come before the European courts in which a breach had been found to have occurred had featured some form of coercion or oppression that either breached Article 3, which prohibits torture and other psychological pressures, or was getting close to that sort of threshold. So it seems that the Supreme Court are saying that the ordinary use of compulsory powers is not going to breach Article 6, but they haven't definitively ruled out a successful challenge in the future, depending on the facts of the particular case. So one imagines that there may be one or two more litigious cases in terms of defining when Article 6 privilege may or may not apply, not just now to answering questions in interview, but also the obtaining of documents and other real evidence that might have been said to have such an independence from the person concerned that previously the English Court of Appeal certainly had said that the privilege had no application. So there's quite a fundamental change in the law there in the face of inconsistent decisions from the European courts. There was a postscript to the Volaw litigation, which was as follows. During the course of all this litigation, which took so long that the appeal went ahead without the documents ever being provided to Norway, and Mr. Larsen was acquitted. So what one had at that point in time was a notice served by the Attorney General, which named Mr. Larsen as the person under investigation and stated that he was suspected of being involved in complex fraud. But the Attorney General didn't withdraw the notice, which had been served on Volaw. What the Attorney General said was this: look, you, the trust company, are now claiming privilege against self-incrimination. That can only really mean one thing, namely there's something in those documents that incriminates you. So I am now opening an investigation in Jersey into you, the trust company. I'm therefore maintaining the notice, and you need to still hand over the documents, notwithstanding the acquittal in Norway of Mr. Larsen. Of course, one can imagine that Mr. Larsen might not have felt very comfortable with that, because after all, although Volaw was now a target of a Jersey investigation, it was going to be all about his business affairs with that trust company. And Mr. Larsen this year brought another judicial review challenge in Jersey, claiming that his Article 6 rights were now being breached, and in particular the presumption of innocence. What he said was, in terms, look, I've been cleared of all charges, I've been acquitted, you have to treat me in Jersey as an innocent man, and if you're maintaining a notice that states that you are suspicious about me, then that is a breach of my human rights. This area of European case law is even more problematic because the European Court has extended the presumption of innocence beyond the ambit of just the criminal proceedings themselves, and have in effect said that in any subsequent proceedings where there's been an acquittal, any action by any public authority that might be seen to cast doubt on an acquittal constitutes a breach of the presumption against innocence. So to give you a graphic example, there was one case that came out of Norway whereby a lady had alleged rape and made a criminal complaint, and there was a trial. The criminal court in Norway were not satisfied that the case had been proved beyond reasonable doubt, and the defendant was acquitted. Matters didn't stop there, because the complainant then sued the then defendant, now acquitted, in the civil courts in Norway, and there was a trial, and the court concluded that yes, indeed, there had been a rape on the lower standard of proof, the balance of probabilities. And the defendant went off to Europe and said, look, my human rights have been breached. There was a presumption of innocence. Notwithstanding my acquittal in the criminal court, there is now a court finding that I did indeed rape this girl. And the European court agreed and said, actually, yes, that is a breach of your human rights. The presumption of innocence has been breached here. The Supreme Court has made it very clear that it does not understand the underlying logic of such a decision, and effectively has refused to follow European case law in this area. There was a case a few years ago in the Supreme Court called Gale, where they didn't quite refuse to follow European case law, but in Gale it was said that the presumption of innocence was only going to be applied in particularly strict circumstances, and certainly they were not going to entertain the sort of decisions that the European Court had been making over the years. Much more recently, in Hallam, which is a Supreme Court case of this year, there were 7 judges that considered exactly the same or similar issues. And of the 7 judges, 5 of them either agreed to follow Gale, or actually 2 of them even said that Gale went too far, and they were not prepared to recognise any presumption continuing beyond the ambit of the criminal proceedings in question. And so the upshot of Mr. Larson's challenge in Jersey was that following Hallam and following Gale, that the fact that there was a notice that spoke of suspicion was really neither here nor there, and his human rights had not been breached. But I think out of all these cases, it's clear that Article 6 is difficult for the Supreme Court because it wants to follow Europe where it sensibly can, but it is increasingly finding itself at odds with Europe because either inconsistent decisions or some decisions, as in the personal injury case, where the underlying logic is very difficult to discern.
Thank you, Howard. I was just going to address privilege against self-incrimination in the context of civil proceedings. Howard, having dealt with it in relation to criminal and regulatory proceedings, I think just to pause there in relation to Saunders, Ernest Saunders, which you referred to, which is the sort of 1990s ECHR decision, that was in relation to the Guinness case, and his DTI transcripts were used in the context of the criminal proceedings, is that right?
Yes, that's right. He had to attend compulsory interviews in the course of various investigations, and these compulsory interviews, you have to answer the question. But at that period in time, I don't think there was any prohibition.
There was no protection.
There's no prohibition about them being used then against you in criminal proceedings, whereas post-Saunders, such powers now come with the caveat that you can't, those answers, although you have to answer the question, they can't be used against you unless there's certain limited exceptions, which are traditionally that you've lied to the person asking you the question. So you can be prosecuted for lying in the interview. But if, for example, if Saunders had admitted in those interviews, yes, I committed a fraud against Guinness, even if that was true, you couldn't use it against him to prosecute him for fraud. So Saunders' case brought in this massive change.
So Ernest Saunders is also notorious as being the only person to have recovered from Alzheimer's, I think. Is that right? He was convicted. I think it was part of it was that he was didn't have to serve any jail time because of Alzheimer's, which was diagnosed by 2 doctors, which he then miraculously recovered from. I think I saw him in a restaurant eating about 5 years later, and actually using a knife and fork all on his own. Anyway, the privilege against self-incrimination, very quickly, I mean, there isn't, in civil proceedings, it exists. What are we talking about? It's a procedural, not a substantive right, in the sense that often in asset recovery cases, fraud cases, we've all heard freezing orders. They are made by the English court, which then have provisions that disclosure is ordered for the respondent or defendant to give about assets and possibly about other matters as well, information and documents and so on. And the privilege is always in the order, which is that the defendant doesn't have to answer, can claim the privilege against self-incrimination if he wants to, if he or she wants to. It also applies to companies as well. And it's enshrined in Section 14 of the Civil Evidence Act. It's one of those things which is in the order. The problem with it is, well, it's twofold. Firstly, it's been eroded. That right to claim the privilege has been eroded over time. So it is only really claimable in a very select number of cases. The Fraud Act in 2006 meant that there were statutory exceptions to the privilege. And normally what it is a defendant is very concerned, if I give you this information to the claimant, you're simply going to hand it over to the police and then I'll be prosecuted. Or I might even be facing parallel criminal prosecutions. As it stands, I might have already been arrested. And there's going to be this sort of information leakage between the civil claim and the criminal claim. I mean, and so this privilege is there effectively to protect that. The Fraud Act was introduced in 2006, and effectively eroded it, so that if any prosecution is brought under the Fraud Act, and I think most police prosecutions nowadays in the UK are brought under the Fraud Act. Effectively, no information which is in civil proceedings is admissible in evidence in those criminal proceedings. So effectively, it sort of got rid of the privilege under that. So it's kind of tends to be used now for overseas criminal proceedings. So if an individual is facing a civil claim in London, they could be facing parallel criminal proceedings in Congo, in Africa, in Russia. And at that point, they'll say, oh, wait a second, I'm concerned that if I give you information, you're just going to hand it over to the authorities in Congo, or it may even be the Republic of Congo, which is in one of the cases, is bringing the civil claim, and also another arm of the Congolese government are bringing criminal proceedings. And there are legitimate concerns there that are made by defendants in those proceedings. So the duty of the claimant lawyer and the court is to ensure that there isn't that information leakage, and that can be done by confidentiality clubs, restrictions on who can see the information that's disclosed, and so on. Or you could get an undertaking from the Attorney General of a particular country that he won't look at it and he won't rely on it. And that normally is the sort of the ready answer, certainly in civil proceedings, to the privilege.
I think there's also an interesting overlap when you're talking about mutual legal assistance of one jurisdiction helping another. In Jersey, for example, the Attorney General's got powers under his investigation of fraud law to compel documents to be handed over or to compel someone to answer questions. And what's handed over or said pursuant to that law can only be used in criminal proceedings. That's under the Jersey statute. It can't be used in civil proceedings. Well, that's fine if it stays in Jersey, but Jersey frequently, as you might imagine, gets requests from other jurisdictions, and it has in the past got requests from European jurisdictions where, when a criminal prosecution is launched, the civil claimants who might be claiming on the back of that prosecution are able to join into the criminal case and have access to the material that the prosecutor assembles, which includes material that the prosecutor gets from overseas. So there's the difficult situation that certainly a case that Howard and I were involved in a year or two ago arises where the Attorney General in Jersey uses his compulsion powers to get material in Jersey. He can only use it for criminal proceedings. And he traditionally asks someone overseas, when they make a mutual assistance request, for an undertaking that it will only be used in criminal proceedings. But of course, if it's, say, in Italy or Austria, where the system exists with civil claimants having access to the criminal files, they simply can't give that undertaking because their procedure doesn't allow them to do it. I think that's a very interesting chink in what locally seems like a very useful protection, but something which completely expires once it gets outside the jurisdiction.
Should we move on to sort of asset freeze and civil forfeiture?
So there was a case in Jersey this year in which I was on one side and Baker and Partners were on the other side, involving police powers of consent. And I imagine many people in the room will be familiar with police consent powers. In England, under the Proceeds of Crime Act 2002, if you're a bank or a financial institution and you're suspicious about your customer's money suddenly for some reason, you can file a report with the police. The police can look at your report, and if they see fit, they may give you consent. And if you get police consent, that is a statutory defence to substantive money laundering charges, and you can pay the money away, and you don't have to worry about being prosecuted. Under the 2002 Act, there's a timetable for these events to take place, and effectively, but putting it crudely, if the police don't get their act together and don't decide to launch an investigation within a relatively short period of time, you are deemed to have been given consent, whatever the police in England might be getting up to. So it's a finite period of time, and the intention plainly was to allow trade and commerce to continue, balancing that against the need for investigations. In Jersey, there's the same statutory regime in terms of the bank or financial services provider files a report, the police considers whether or not to give consent, and if consent's forthcoming, you've got your defence, but there's no time limits. So the police in Jersey can withhold consent, and in some cases they've withheld consent for some considerable period of time, often, or in some cases some years, and funds have not moved because the bank has been worried that if they move the funds, they're going to get prosecuted. In the 2019 case of prospective applicant, which is an anonymised name for the real person versus Chief Officer of Police in Jersey, the position was that the police had legitimate cause to be suspicious about the particular funds, but at the time of this judicial review action, the police had not formally opened any investigation, and nor could they tell the court or promise the court that any investigation would be so opened. And so the issue was, or one of the issues was, given that there was no active police investigation, I should say in Jersey or anywhere else for that matter, because there were links to the United States of America, but on the face of it, nobody was investigating these funds. Were the police really entitled to withhold consent? And if so, how long for? And the issue for the court really was one of, well, what is the police consent power at its heart? What is it in substance? And there was, the argument was about this. Was it a power that's analogous to a power of immunity? That's to say, you're simply giving someone a defense to a substantive criminal charge? Or was it, in fact, a freezing order, a restraint on somebody's property? What happened ultimately was that the Jersey court went for the immunity argument. That's to say that what consent was really about was simply deciding whether or not they were going to be given a statutory defence. It wasn't, in fact, any infringement on anyone's property rights, because the person concerned was still perfectly free to move their property wherever they wanted. The only caveat was that they weren't free from risk of prosecution. But that's the same as everybody else in the island. Now, whether you agree with that or not, that's the argument that was put before the court. And there had been a bit of history to this in the Channel Islands, in that the Guernsey Court of Appeal had in a previous case reached a same or similar conclusion. And in the Channel Islands, the Guernsey Court of Appeal judges are the same, or very often the same, as the judges who sit in Jersey and Jersey's Court of Appeal, and therefore the Guernsey decision was highly persuasive. And so what happened was the Royal Court followed this Guernsey decision, and therefore, despite the fact that there was no investigation, and despite the fact there may never be an investigation, at that point in time when the decision was handed down, there was found to be no breach at law on judicial review classic grounds and or under human rights law, under Article 1, Protocol 1, which protects people from undue interference with their property rights. There's found to be no breach of the person's rights at all. It was going to go to appeal, which would have been very interesting because I think the Royal Court felt it had to follow the Guernsey Court of Appeal. It would have been more interesting if the appeal had gone through, but unfortunately the case settled. But there's no doubt that the Jersey police powers of consent are considerably broader in effect than their English counterparts.
Can I ask a question just under Jersey law? Let's say that you have a client, so claimant, victim, fraud, identifies that there is money in a Jersey bank account, but doesn't want to spend money getting a freezer for whatever reason. You read about the sort of informal freeze in Jersey and Guernsey as well, and it's quite effective. So if they were to write a letter through a lawyer to the authorities in Jersey or Guernsey, and they were to write a letter to the bank saying, and giving full evidence, without going through the rigmarole of applying for an expensive freezer, what is the likely reaction to that going to be? I mean, I know there's obviously always risks involved, but would you ever advocate that as being a sort of alternative to getting a freezing order?
Well, the reality is, I mean, you can talk about human rights as much as you like and what the approach was in that case, but this power allows the police to impose an informal freeze without having to go to a judge and go through all the rigors of dotting the I's and crossing the T's and getting a restraint order. I think that in the circumstances that you describe, yes, it would be, it would achieve what someone wanting to stop the funds moving set out to achieve. What happens after that is the issue then, because what are the police going to do? In fact, there may be an investigation which a claimant wouldn't appreciate.
In a way, you could do it pending an application for a freezer.
Yeah. Yes.
Or more formal application.
Yeah.
Yeah, the Jersey law is, I think, now consistent with English law, whereby it's an offence not to report a suspicion. So if you were going to give your bank, assuming it's credible material that's of substance, it'd be very difficult for the bank not to report that. And equally, one would imagine it'd be very difficult for the police to at least immediately give consent. So if you're looking for some sort of stopgap whilst you get your papers in order to get your own restraint order, then it may be a very effective way forward. Though, of course, it's not guaranteed, and there are some other risks one can think of. But assuming you've got good material, it could be a very effective and quick solution to bridge the gap you're talking about.
And what is the longest freeze that's gone on in Jersey in terms of money being frozen, bank accounts frozen? Is there a sort of a well-known?
I can give you. You asked me to deal with the President Moi case.
Sure. Yes.
So Winwood Trading Limited was a company set up by a senior Kenya public official who was in charge of awarding, amongst other things, in charge of the tendering process for the electricity sector. So if you were a European company that wanted to build a power station in Mombasa or do electricity lines out of Nairobi and into the countryside, you would have to pay Winwood Trading a bribe if you wanted to succeed in that tendering process. And a number of well-known household European companies paid money into Winwood Trading, and that was then shared between the public official and the energy minister at the time. In terms of the police consent, the report went into the police in 2001, and police consent was withheld until 2010, where then a SAISI, which is a formal court order obtained by the Attorney General, was obtained. So 2001 to 2010, extradition started in requesting the public official on the energy minister in 2011, which is going to the Kenyan Supreme Court next month. In between, because extradition's been going on so long, and talking about attribution of company in the controlling mind, because the Crown was able to show that the company was being controlled by its beneficial owner and not the directors in Jersey, we were able to prove or attribute the public official's guilty knowledge to the company and prosecute the company in 2016, secure a conviction against the company and confiscate what was left of the company's assets, which were the proceeds of corruption.
But in fact, there's another chink in terms of the informal freeze that's just, there's a new statute been enacted in Jersey this year, dealing with civil asset recovery. It was enacted as a result of a Moneyval report, which commented on the inadequacy of Jersey's civil asset recovery as opposed to criminal confiscation. And one aspect of that legislation deals with this no consent issue, because if funds are held in a bank account and they have been subject to a no consent by the Jersey police for 12 months, then there's a new summary procedure, as it's referred to in the legislation, which enables the AG to summons someone to court. He doesn't have to get a judge to issue the summons. He summons someone to court, and that person then has to come to the court if its funds have been informally frozen for 12 months and the burden then passes to that account holder to come to court and to prove the provenance of the funds. And if the court isn't satisfied that the account holder has proven the provenance of the funds, then the funds will be forfeited. So not only have you got this no consent for very lengthy periods as a feature of Jersey proceeds of crime law, now you have the ability of the Attorney General to, at relatively short notice, bring someone to court and demand that they prove what the money, where the money came from. Like so many pieces of innovative legislation or new legislation, like the Bribery Act in the UK, the first cases we're seeing coming through are pretty minor and not the sort of big sums that perhaps Moneyval had in mind when it made the recommendation. But we're seeing a first decision that's just come through about £30,000 worth of funds that had been deposited with a local bank in the 1980s by a Scottish gentleman who'd run a successful taxi business. The Scottish authorities in 2002 requested the funds be frozen on the basis he'd been charged with drug trafficking offences. They'd remained subject to a no consent. And then in 2019, the AG invoked the summary procedure, brought the man to court who said, no, it's not drug trafficking offences. But in the course of explaining why it wasn't drug trafficking offences, what he did say was, I put it in Jersey because I thought I didn't have to pay Scottish UK tax if I put it in this Jersey bank account. And so the Attorney General quickly changed his position and said, oh, well, if it's not drug trafficking, then it's tax evasion. And the court thought, concluded, yes, that's right, we haven't been satisfied by him that it isn't tax evasion, and therefore we're going to forfeit it. And there may be eyebrows raised in certain quarters about this new power being used for the first time to effectively enforce tax evasion in the UK. And on one view, we've come quite away from the seminal authority in the 1950s, Government of India and Taylor, where it was held that the English courts may not directly or indirectly enforce tax claims of another sovereign state. And that seems to be, by dint of the facts of this particular case, exactly what the New Jersey confiscation legislation, civil confiscation legislation has done.
Okay, I'm conscious about time, but I think, Simon, did you want to deal with liability of parent companies? All right, well, look, I'm conscious, and we're keeping you from your drinks. Does anyone have any questions at all that they want to put to us? Yes, please. I'm not sure we've got a microphone. I think it's coming on now.
Okay. Yeah. So my name is Sigrun Davidsdóttir. I'm an Icelandic journalist based in London. I've heard of some cases coming up in the European Court of Human Rights where, for example, somebody who has been sentenced in one country for financial something have then sent their cases to the court, and the court has sort of in some way gone with their claim. Somebody told me that the first instance of the court is not very well manned, in the sense that the sort of ability of the judges there was disputed, whereas if it went to the second instance, there were judges with greater insight, more ability, or whatever. Can I ask you if you have any view on this?
I'd go so far as to say that the higher up you get in terms of your appellate courts, the more experienced and the judges in the higher courts are very clever people, but I wouldn't go so far as to say that that means the people at first instance are not.
Okay. Anyone else? No? Okay. Well, look, Thank you very much. Thank you for listening, and enjoy your drinks. Thank you.